Thank you, Your Honors. May it please the Court. I am Attorney Wesley Buchanan, and I have the privilege of representing Traci Smith, who is the appellant in this matter, and I would like to reserve 5 minutes for rebuttal. Traci pled no contest to violation of Wadsworth Codified Ordinance 90.01B3A. Now, our proposition is that because she pled no contest, she admits all the facts in the complaint, and that ordinance does not specify a mens rea or mental culpability state. And there's no plain language indicating that that statute or ordinance is a strict liability offense. So the ordinances of Wadsworth itself say that if there's no mental state stated, then recklessness is the default state. And there was no recklessness shown by the government. When the trial court took Traci's plea of no contest, there was no stipulation of guilt, and there was no presentation of facts. So the trial court could have found her not guilty based upon what was presented, even construing the complaint in this matter all the way in favor of the government. And because of Revised Code 290121B, that is where the plain language of strict liability comes, and because there was no strict liability plain language, our proposition would be that it's a recklessness. Now, this court in Akron v. Messner, and I'll give a case site here, of 92, Ohio App 3D1, at page 4, in another case that involved dogs running at large, reversed a conviction using the same manifest weight standard, and found that the Akron City Ordinance in that matter did not specify a culpable state. And because it did not state mental culpability, and it did not plainly indicate that it was a strict liability offense, then recklessness was what was needed to be proved by the government. In that case, the government didn't prove recklessness, so the conviction was reversed. So I would indicate for this purposes of today's hearing, this case is very, very similar to that case in the sense that Traci was elevated to a misdemeanor of the 4th degree. She was sentenced to 30 days in county jail. 23 of those days were suspended. So she was given, in essence, a 7-day county jail term for this because it was elevated because of previous convictions.
Has that been served?
She is not, because of the trial court stayed all the fines and the imposition of the sentence pending the outcome of this case at the appellate level. So she has not served any time. She has not paid any fines to my knowledge, and the record will reflect the same. The 10th District also reversed a conviction for dogs running at large, and I did cite that in the brief of Bexley versus Seltzer for the exact same reasons that this court so did. It reversed a conviction based upon the manifest weight and found that the evidence was insufficient as a matter of law because there was no strict liability standard set in the ordinance, and there was no plain language indicating that it should be strict liability. So those two cases are very similar to what we have today. The government had an opportunity at the presentation of facts to say that Traci left a latch open, left a door hinge, acted recklessly in some regard in their ability to present facts to the court. But because there was no presentation of facts, the complaint, as it's read, states and recites the ordinance, but there's no how of the ordinance was violated. There was no because she left a latch unlocked or because she left something, the doggy door unlatched, her dog Titan got out and did in fact kill a cat. So there was no presentation of the facts in the trial court. So it was our position that the trial court could have found her not guilty of this offense.
And there were several prior convictions.
Correct. Yes, the trial court ordered a pre-sentence investigation. There were prior convictions for dogs running at large, and that's why it is elevated to a misdemeanor of the 4th degree. And that was all based on a pre-sentence investigation at the sentencing hearing, which was at some time later after the plea was taken. So our position would be, based upon the evidence, the lack of evidence shown at the presentation of facts, that the government did not meet its burden for showing recklessness of Traci, and thus the evidence against her was insufficient as a matter of law, and that her conviction should be reversed. Also, the Criminal Rule 11 requires that the court to have a meaningful conversation with the criminal defendant. And in this case, there were several, as the brief indicates, rights that were left out by the trial court, and that right that she's utilizing today as her appellate right wasn't even indicated to her. So, in addition, I don't believe the plea colloquy that the trial court had met the standard of Criminal Rule 11 that it should have, and thus it wasn't knowingly, intelligently, and voluntarily made. And with that, if the court does not have any other questions, I will wait for rebuttal.
That's fine, thank you.
Thank you. Good morning,
Good
Your
morning.
Honors. My name is Tom Morris, and I represent the city of Wadsworth. On December 8th, 2014, the defendant expected a sentence on her dogs at large to go much like they had done on June 10th, 2013, where she had pled no contest and was sentenced on it, on June 21st, where she pled guilty, on August 22nd, 2014. These are cases that occurred prior to this case, and they were all dogs at large. But on December 8th, it didn't go as expected because the judge had enough. He gave her 7 days in jail, which she had a right to because it was a misdemeanor in the 4th degree. I don't believe we're here because she didn't understand the effects of her plea. We're here today, I would argue, because she didn't like the results. She didn't like that this time it wasn't
the effects of her plea the same as the results?
No, the sentence, she didn't like the sentence that she was given. She knew she was going to be sentenced. She understood that she was going to be sentenced. It was voluntary. But she didn't like getting put in jail for it.
But if you have a no contest, and I don't know if the prosecution was there for this, if it was
It was me, so yeah.
Okay. Well, in not every municipal court does the prosecutor appear on misdemeanor arraignment, recommend a
It
sentence.
was not an arraignment. This was a change of plea. That was at the day of trial. So the trial was
Okay.
scheduled. We were ready for trial. She was represented. She was represented by counsel, and that counsel put on the record that he had explained to Ms. Smith her options, looked over the discovery, potential and possible penalties, and he believes she's entering a plea knowingly, intelligently, and voluntarily.
Well, the only reason I mention that is because I was hypothesizing that in some cases that we see, since the prosecutor may not be there for an arraignment, and I understand this wasn't, but sometimes a recitation of facts is not made, nor is there a waiver of the recitation of facts. But that's not the case here.
Well, there was a hearing, and I was there. The prosecutor was there. Take me out of it, I guess. And the record reflected that there was a no contest with her attorney on occasions, and I've practiced in other courts. The judge will say now, state, put a recitation of the facts. That was not done in this case at the time. Judge McElvain was not requiring that. That's subsequently been changed. But there was facts that were discussed. There was facts were put onto the record, or at least on the record, afterwards. There was a discussion that, no, this was a dog case, that dogs at large, where the dog got out and attacked a cat, killed a cat, and that's on the record. There was a discussion whether should we go right to sentencing, and the prosecutor advised the judge that this was 4th degree misdemeanor, certainly in the presence of her counsel and her, saying, no, this is one where you got to do a pre-sentence investigation to get a victim impact statement and the like. So while there wasn't that formal back and forth that you often see now, prosecutor do a recitation of facts, there was a recitation of facts, just not in the order we typically see.
Well, two things. One, it wasn't
Sure.
before the plea was entered.
It was not.
It
You're
was
right.
pertaining to sentencing as to how severe the sentence should be. Is that correct?
No. It was on the change of plea date. The change of plea date was on November 4th. The sentencing didn't occur until December 8th.
I guess what I'm getting at, though, counsel, is you can be convicted of a dog at large without killing a cat or without creating harm to other people, right?
Correct.
Okay. So that was talked about as to the results of her allowing her dog to be running loose at large. But what was on the record, if anything, pertaining to how the dog got loose?
There was nothing on the record which pertained to how the dog got loose.
And your position is it's a strict liability and it doesn't matter that
Correct.
you didn't. What if little kids in the neighborhood went and let the dog loose? Is the owner still responsible for that?
Yes.
Criminally liable?
Strict liability.
The
It's
statute doesn't say strict liability.
3 courts have
Right.
found that it is strict
Right.
liability, but the statute says no owner shall allow.
Right.
But
That
doesn't it seem to imply when you say allow, if the neighbor kids come over and open the gate and, or even say vandalize it and break the gate's lock and have the dog come out, how is that the owner allowing?
Is the owner allowing if, say, a criminal came in the back door and opened the door and the dog ran out? I don't believe that would be.
But if it's strict liability.
Well, I think that's the discretion of the police officer and or the prosecutor. I think you go back to cases in law school where if a lion gets out of his cage, it doesn't matter whose fault it is, it's strict liability. Does that lead to some unfair results? Sure it does. If children did nothing and somebody left it out, a non-culpable 2-year-old or what have you, it can lead to results that are harsh, but that's strict liability says, is that you have to do something affirmatively so that doesn't happen.
Well, I guess my point is, in regard to any ambiguity, when you say allow, no owner shall allow, it seems like an affirmative act of some type.
There's a shall, so it's mandatory. It's not do your best. It's not no person shall fail to, by negligence standard where they put it in there, it just says shall allow. So I believe it's strict liability. But the cases that were cited, Bexley, and I'm not familiar with the 9th District one that I was referring to, but based on what he said, it's my impression those were trials, and we're trying to figure out what the standard is when a judge is reviewing a trial. Certainly that comes up. This was a plea. This was a plea with a attorney who could have made those arguments and said there was failure to have recklessness and had a trial on it. We were there for a trial. And there's a second part to this where I bring it up just so that nobody gets confused. There was a dangerous dog classification hearing that immediately followed. So there was some additional stuff talked about after that.
I guess I'm just trying to figure out, I understand there is an attorney who's supposed to be there to protect her rights, but I guess, is it the attorney's duty to say, oh, by the way, you don't have the facts, you don't have recklessness in your charge, you haven't presented recklessness? I mean, that's almost arguing against this client, isn't it?
Well, I think what you say is we tried the case. We're here for trying the case, and then say you can't show it was reckless because...
But she didn't plead guilty. She pled no contest.
She did. And there's no question about that. And in an ideal world, what I would have liked to have seen is that the judge would have a recitation of facts and place that on the record, and then that's in front of you, and then we don't have any questions. Or a plea of guilty. And a plea of guilty, you don't have some of these issues. That is why this isn't the perfect colloquy between a defendant and a judge. But in municipal court, sometimes it doesn't get so perfect because there's a lot of them, and you go through quite a few. And that's why it really comes down to the standard, and that's really the second part of the argument, is what is the standard if you don't read all your rights? And in this case, the judge didn't. The judge left off 2. The judge didn't say you had a right to represent yourself, or you have a right not to incriminate yourself. So we go to the Criminal Rule 11. Criminal Rule 11 tells us that under D, that if it's a serious effect, that the judge has to explain the effect of the plea, and then the judge has to make sure it was voluntary. Well, this wasn't a serious charge, and these are definitional things. It's not how commonly said. This was a petty charge, and under petty charge, under 11E, all you have to do is the effects of the plea. And in this case, the judge asked, do you understand the effects of the plea? And she said yes.
That's been amazing to me, because Judge Moore and I both were former municipal judges and handled thousands of cases, that you can sentence somebody to jail and not have to read them their entire rights under Rule 11.
Well, I think you do under constitutional analysis, and this is where I'm coming clean, saying that's what the rules say, but I don't think that's the rule. The rules say one thing, but I think under the Constitution, under due process, we have to do a little bit more. So I would agree with you on that, and I'm not going to come up here and say that you don't. But the question is the standard. What is the standard that we have to do? And the standard is substantial compliance. That you have to substantially comply with all the, 5-minute, 3-minute, however fast you talk, back and forth with each defendant.
and you look at the totality of the circumstances. So when I would see these cases, the question is, what are you going to have on your record which is going to help you determine what she thought in terms of would she have done this had she known that she had a right to testify? And then, every police show you've ever seen says you don't have to testify, can't be used against you. What if she would have known that? Would it have been differently? That usually comes in through a motion to withdraw your plea. You can do it before or you can do it after. There are provisions for both. And then you would have on your record, she wouldn't have done this other than the fact that she didn't know this. But you don't have that. Certainly the implication, since she went through this 3 different times, is that she knew she had a right to a trial. She had a right to a jury trial in the Fourth Amendment, or the fourth degree misdemeanor part, that anything she says will be used against you, blah, blah, blah. All of those rights she had been through before. She knew the effect of the plea because she's done it before. She had an attorney who explained that to her. The judge asked, do you need any further explanation as to the pleas available to you? She said, no.
Was she ever asked? I'm trying to remember, I
Sure.
may be putting this case in the place of another one, but was there a motion to vacate the plea?
There was not.
Okay. So she was never asked whether, had she known these other rights, she would have pled or foregone pleading?
Correct. So now we're at a totality of the circumstances standard, and we really don't have enough for you to help make that decision. All we have is the fact that she's represented by counsel. Counsel says that he believes it's being done knowingly, intelligently, and voluntarily after he's reviewed the evidence with her and all potential defenses. And we have the judge going over 90% of the rights, not all of them. Should have done them all, but didn't. But substantially complied with that, and a person who's been through this system before on the exact case, and in fact pled no contest in that case too.
Well, if
It
it were
wasn't
a
just-
felony case, we wouldn't be talking about substantial compliance because there's some constitutional rights that we're not.
Well, we got constitutional rights and we got statutory rights, or criminal rule 11 rights.
Both of them, and in a felony case, we wouldn't even be talking about
Right.
substantial compliance.
We're talking about a petty case, so the rules are a little bit different. But due process is around for all of them, I would say. So the question is, did she understand what was going on? Was there substantial compliance? Or when she got a result different this time than every other time, meaning got sent to jail, is that when she said, oh, I got to get out of this. I got to file an appeal. I got to do something. I don't want to go to jail. Instead of, I didn't understand that I didn't have a right to an appeal. And you see cases like that where they said, well, I pled no contest because I was going to appeal, and then I waived my right to appeal on a motion to eliminate. That's not this case. The cases I've seen that involve someone not understanding it wasn't a knowing, intelligent, and voluntarily, usually involved in a motion to eliminate that they ended up pleading no contest because they wanted to appeal that, and they couldn't because they waived their right to appeal. Not really the case in this one. Certainly didn't read the right to appeal, but she appealed. So, I mean, obviously she knew that she had the right to appeal. And it's a question of was it knowingly, intelligently, and voluntarily done for constitutional reasons. And I certainly think when the attorney says, I've explained to her options, looked over the discovery, potential and possible penalties, and he believes she did it knowingly, intelligently, and voluntarily. And when the judge read her the rights, she was okay with it. She only became un-okay with it or had problems with it once he gave her a more severe punishment than perhaps she wanted. There's no other questions?
No, I think that's it. Thank you. You got 5 minutes.
Thank you, Your Honor. May it please the court. The court found Traci guilty on the first 3 pages of the transcript in the record before this court, when it had the colloquy and the substantial compliance issues there. So the evidence before the trial court was that she pled no contest. So really, I don't think this is a case of buyer's remorse. I think Traci has the right to make the government prove their criminal statutes, and for criminal culpability to attach, this ordinance requires recklessness. Recklessness is required because it does not state it's a strict liability offense, and there was no overt act as this court has stated before, that is usually required to show reckless conduct. So I would indicate that because no reckless act was shown by the government, there was no presentation of the facts. The government did have a lawyer there, and they were free to present the facts, and there was no stipulation of guilt, then the record before this court would indicate that there's nothing showing that overt act that could attach criminal liability to Traci. If she's negligent, that would be one thing, but negligent, in our opinion, would not make this her criminally liable because there's recklessness required. And if the court would like me to answer any questions or address anything else, I would be more than happy to do so.
I don't believe there are other questions, so thank you.
Thank you so much.
Thank you both, gentlemen. We will take the matter under advisement and issue a written opinion that will be sent to both of you as well as released electronically on our website. Thank you.
Thank you.